About about a month before I graduated last year, I was able to catch up with one of my old college friends, and he's in Tokyo, so we had to schedule a Zoom call, and we were catching up. And he says, "You're going to be graduating next month, right?" I'm like, "Yeah, I am." "So what are you going to do with cybersecurity?" I said, "I'm going to do more paperwork." And he thought I was joking, but I was being honest. I was like, we got audit reports, we got pen tests, we got risk assessments, we got NDAs, contracts, training materials, you name it. There's always going to be paperwork. And the reason why I do paperwork is my main focus is governance, risk, and compliance. But it was paperwork that really got me started in cybersecurity back in the late 90s. So let me give you a quick tutorial of what the 90s was like for cyber. So as you can see, you can pretty much recognize most of these laws that were passed in the mid-90s. By the way, I'm not an attorney, although I've worked for lawyers. I'm going to comment on some laws and some litigation and some rules and regulations, but those are based upon all the experiences I've had as they affect my career and the industry as a whole. So as you can see, the Telecommunications Act of 1996 was passed. They gave us, Section 230, Communications Decency Act, the 26 words that created the internet. Most people don't know about the Clinger-Cohen Act of 1996, but that was passed to help modernize the Department of Defense. It helped establish the very first chief information officer role for the Pentagon, as well as all the needs of what they wanted to do for modernizing their operations. Of course, we all know HIPAA, Health Insurance Portability and Accountability Act of 1996. I mentioned in the parentheses, it's also known as the Kassenbaum-Kennedy Act of 1996. And of course, you have the Digital Millennium Copyright Act of 1998, which protects copyright materials online, and the Gramm-Leach-Bliley Act of 1999, which was passed to protect financial data. Two important things we should notice here. There was a lot of bipartisanship going on in Washington, D.C., both not just with Democrats and Republicans, but also the House and the Senate. Everybody wanted to get together and make this work as far as how this new technology was going to move forward. This is back when people were still calling it the information superhighway, and we were going to be building a bridge to the 21st century. Well, here we are. And so the other thing we should note, both HIPAA and GLBA are related in that it was HIPAA that created the privacy and security rules, particularly the administrative, technical, and physical controls that were pretty much leveraged to be put into GLBA as well. So you had two similar tracks, one protecting health data and the other protecting financial data. And while you may be studying that in your cyber programs, there are those of you like myself who also had a lot of experience following those privacy rules throughout our career. Going back to the Clinger-Cohen Act of 1996, a year later, Senator Cohen became Secretary of Defense Cohen. And in 1997, he was working with the Pentagon, he was working with Vice President Al Gore to make a bipartisan effort to upgrade the Department of Defense functions. And this is a screenshot from a press conference that occurred in November of 1997, where he says, we're gonna cut out the fat and build more muscle. And these two screenshots are very important because this embodies everything that got things started for digital integrity when it comes to going from paper to images. And so what you see him holding up is basically an entire stack of documents that would fill one banker's box, and it would be scanned, it would be coded, and it would be burned onto that one disk. And so we've gone from this to disk to saving our documentation on encrypted servers to saving it into the cloud. But this process is still ongoing. I have a friend of mine who, he's got a new job now, but last year he was working for a company that goes to city, county, state, federal archives, and they go and they're still digitizing documentation because it's part of the public record, and those government entities are going to want it, not only for their own personal references, but also if citizens need access to it as well. And so this happened on November 10th, 1997. And at the same time, 3,000 miles across the country, I was working in downtown San Francisco for a major law firm, and they had the exact same drive to go digital as well. And it's not just a government thing, it's separate but related. So being in San Francisco in the late 90s, you had the opportunity to be a part of cutting edge technology at the time and be able to start digitizing documents for litigation. So this is a screenshot of what summation used to function as. Summation was the out-of-the-box platform that was used to scan, code, and image all litigation images. And so what you do is you actually go through the boxes of documents and you put them in chronological order, and you physically determine whether or not you have a to, a from, a CC, what's the communication regarding, are there any attachments, are there any keywords, are there any handwritten notes, so on and so forth. It was a very manual process. And you have to realize that this being the late 90s, what we know today as far as Adobe Acrobat and OCR really didn't come into vogue till another decade, around Great Recession time. So this was still very much a manual process. And what you also did learn about was, what are the key docs in a case? And those key docs, you would line them up and you'd be able to develop the narrative for why the case is going to trial. And so it's not just making sure the pages are properly scanned, but also learning, making sure that you're doing right for the client to make sure that the data is accurate about the documentation that they've provided. And so while this was a great time to be in San Francisco in the late 90s, you get to that point where you realize if you want to stick around, it's going to cost a lot of money. So I decided, you know what? I'm going to come to UD for graduate school instead. So I came here in 1999 and was in the master's program for philosophy. Eventually I had to leave and start getting a new job. And since my skill set said, hey, you can work for a law firm, I went to work for a few law firms in downtown. Of course, there's confirmation bias. I'm thinking, hey, I worked in downtown San Francisco. It's the late 90s. Let's do the leading bleeding edge of technology. Downtown Dallas is just like that, right? No. I walked into a room about the size of that little alcove right there, and it was nothing but paper. And so here you go. I'm like, but I can't scan it, I can't search it, and I can't save it. Eventually, I found another job across the street to another law firm, and they were doing their own in-house documentation system. Instead of an out-of-the-box thing like summation, they call it the DMRS, Document Management Retrieval System. And so from there, I was able to do pretty much the same thing in terms of document management, but also I'm going to give two examples as far as cases that I worked on in terms of their importance for the sake of cyber. So this is an excerpt from a decision that was issued back in 2007, and I'll read it out for you. And so just so you all know, UT means University of Texas, HQ means Hydro-Quebec, and NTT means Nippon Telephone and Telegraph, which is the Japanese version of AT&T. And it says, UT HQ alleges that an NTT research scientist learned of a confidential information for a certain lithium rechargeable battery technology while visiting the University of Texas at Austin from 1993 to 1994 under the tutelage of a UT professor. Upon returning to NTT in Japan, the research scientist disclosed this confidential information, which NTT used in November 1995 to apply for a Japanese patent that was published in May 1997. And unaware of NTT's misappropriation in patent application, UT filed for a provisional US patent in April 1996 and entered into a licensing agreement with HQ in January of 1997, giving HQ exclusive rights to the lithium rechargeable battery technology. UT's United States patent was granted in June 1999. UTHQ asserts NTT's Japanese patent interfered with their ability to commercialize their licensing agreement. So in terms of this particular case, not to say that it's the only case, but it is a great example in terms of corporate governance challenges, as well as how this affected the cyber industry as a whole. The first being, since you have international partners, you have Hydro-Quebec, by the way, since it's Quebec, all their documentation was in French. You have all the documentation from Japan, that was in Japanese. And of course, all the documentation here in Texas, you had to go make sure that everything that was properly translated and it was properly understood by everybody as it goes through the discovery process and the depositions and all the things that were attached to the filings with the court. There was enough paper in this case, without hyperbole, to fill this entire room. However, the question arises, if UT had actually acted like a business and had these scientists sign an NDA to say that what we're doing here is confidential, you have them sign an arbitration agreement that says, we have a problem, we'll do private dispute alternative resolution and not in the public courts. And 3, you would have had them sign an ownership of works document saying anything you created, discovered, invented, or anything else for that matter, that is the sole ownership of UT and not your technology. And we'll revisit that later. Oh, sure. Right. Cool. And because this case eventually settled, if I remember correctly, 2010 or so, if you remember about 10 years ago, all of a sudden you start seeing commercials on TV for rechargeable batteries that power your lawnmower and your weed eater and your chainsaw and your drill or any other type of kitchen appliance. So making sure that the rights for these technologies are properly documented will enable you to go to the market with a really great invention. The other thing that was going on at the time, this was about 20 years ago, as the case was really picking up, not all lithium-ion batteries were stable. So if you do some Google searches around 2002, 2003, you'll find that somebody's on their cell phone, all of a sudden the cell phone explodes in their ear, or somebody's working a laptop and it explodes because those batteries were not stable. And so this case, like I said, it's not the only thing, but it did help determine what was the correct formula for rechargeable lithium-ion battery and making sure that it got to market with the right licensing and the right technology. And of course, now as things move forward, everybody wants to push everything to EVs for cars instead of the combustion engine. So this is one example of my road in terms of how things go, in terms of the long game for cyber. It's not just technical controls, it's also the accessories that get us there in the first place. The second case I worked on, and I'm going to have to speak in vague generalities because it was settled under confidentiality agreement. I will say this, that our client, it was a classic David and Goliath case. Our client was a startup and they were trying to get business with a very big tech company, not a Silicon Valley company, but still a big, long-standing tech company. And that big tech company pretty much ran him over, took him over, and put him out of business. And the other catch was it was a contingency case, which means instead of billing at an hourly rate and the firm could be able to collect, a monthly invoice from the client, it says, all right, well, we have $250,000. All right, we'll give you $250,000 and we'll work on the case. But if you settle or you win in court, we get a percentage of the winnings. And then if you lose, well, we'll figure something out later. But that's pretty much how litigation works in terms of contingency cases. But since it was a contingency case, no one in the firm wanted to work on it because you didn't get to bill hours and be the big hero. So I, with an attorney and maybe one or two other people, realized that this is a genuine David and Goliath case. And so we dedicated ourselves to it. We worked with the client on it, and we started going through the process of discovery. Now, for those people who take the cyber classes and you learn about emails and how they work, you have the parent-child relationship. So like I emailed Jerry with my PowerPoint for this presentation. I sent her an email, and then the child is the PowerPoint. The Goliath company decided to deliberately scramble their discovery results. So with a stack of paper, over here is the email, and all the way down here is the attachment. When the email says forward, see this, there's no attachment. Where's the attachment? And so we figured out from not only a digital forensics perspective, but also from a manual perspective that they are deliberately spoiling the evidence as they provide it to us. And as the case progressed, between having an outside vendor that specialized in digital forensics to prove that they were doing this, as well as the fact that we were able to prove it elsewhere. We filed in court a motion for sanctions, spoliation of documentation. And as a result of that motion, rather than fight it in court for a public fight, it was settled and the client won. That was in June of 2006. 6 months later, and by the way, December 1 is a key date for any new rules when it comes to federal rules and regulations. So on December 1st, 2006, new amendments to the Federal Civil Rules procedure governing the conduct of litigation in the United States federal courts took effect, the culmination of more than 5 years of drafting, discussion, and public comment. Language inserted into 6 separate federal rules, 16, 26, 33, 34, 37, and 45, now guides lawyers and their clients on the implications of litigating in the digital age. So basically, I was fortunate enough to be ahead of the curve of these rules. Here's the catch. Now they're actually in place, everybody's got to play by the rules. And having said that, after I was able to have this feather in my cap in my career, I was able to move on and get a job in-house for a company in their legal department. And once that happens and you're on the other side of the door, you face a whole host of challenges. So let's go on with what we had to deal with in the 2000s. You had online defamation on websites by former employees and competitors. Actually, let's take a step back and talk about how the internet back then is not what it was today. So let's remember that in 2006, I think it was 2006, YouTube was acquired by Google, and then everybody started uploading their cat videos. I was watching a couple this morning, I'll be honest. Facebook was still being used only by students. I think the release to the general public was around Great Recession, if I remember correctly. Twitter was in its infancy. I think it got a big break in 2007. Of course, also in 2007, the iPhone was released, and therefore the first smartphone, which meant all the other apps that go along with the phone. There's no Instagram, so on and so forth. So it was a very fractured internet, but you still had these dedicated websites that were existing to just simply denigrate companies and their executives. And again, corporations weren't really ahead of the curve in terms of making sure that you had a social media policy. Most people weren't signing arbitration agreements or NDAs. And so you get all this stuff online. What do you do about it? Well, you can file a DMCA notice, as a result of the Digital Millennium Copyright Act of 1998. Hopefully, God willing, we'll get it taken down. And competitors were doing the same thing, which would then also proceed to having companies start suing each other. And so if you start suing each other, well, then you're going to have to adapt to new rules of e-discovery for litigation. And also, after that rule took effect in December of 2006, magically, anybody who was dangerous enough to know how to image a hard drive, have an LLC and a website to advertise their services for an hourly rate of $250 an hour, I can be your cyber digital forensics expert on all things litigation. So all of a sudden, not only do you have to play by the rules, you got to pay for the rules too. So that was another thing in terms of the companies that had to deal with the internet in 2000s. Making sure that your company has some type of registered mark with the USPTO or with your local state, Secretary of State, gives you the paperwork to make sure that you can fight any type of cyber squatting actions with meta tags. Means if you do a search for your company on Google, then all of a sudden magically there's an ad for your competitor. Why is that happening? You go into the properties of that ad, and you'll see that the competitor deliberately put your company's name in their code as a meta tag to make sure you can search for that. Well, that creates a whole nother fight from a legal and cyber standpoint. Lack of controls regarding corporate property and resources. VPNs were available in the 2000s, but they weren't required or mandatory like they are today. I mean, it was more of like a corporate culture if you're going to use a VPN, but hey, if Wi-Fi still works, why have a VPN? Okay, fine. But then if you don't properly harden your hard drives and you don't properly track other resources such as company credit cards, and then all of a sudden people leave or go rogue, you're responsible for either what content may or may not have been downloaded on laptops or charges that were put upon your cards. So not a good thing to clean up either. And then of course you had government investigations due to operating in an unregulated market, particularly the finance space prior to the Great Recession, prior to Dodd-Frank. There was a lot of that going on because everybody wanted a piece of the same pie and everybody was pointing fingers at everybody else. And it really just became more of a extension of frat boys fighting with each other. But then again, of course, if that didn't happen, I wouldn't have a job. But that's all this lack of cooperation and consistency pretty much, was another reason why we had the Great Recession. So after that happened, let's move on to another rule that went into effect. So in 2007, again, December 1st, 2007, this is the Bankruptcy Rule 9037, privacy protection for filings made with the court. So again, in 2007, this was the new rule to protect individuals' data, because every time somebody files bankruptcy, there are a variety of documents that are filed. There's a thing called a proof of claim. So say you file bankruptcy and you owe money on your car. Your car is subject to your bankruptcy, and your creditor, whatever bank it may be, will file a claim and say, well, they may be in bankruptcy, but they still owe me this money. The whole point of this rule is to protect you, to make sure that the last 4 digits of your social security number or your taxpayer ID, the last you have everything redacted to the year of your birth. Make sure the full names of your children are redacted, and make sure that your account identifier would be redacted the last 4 digits. So basically you have 5 identifiers that need to be redacted before a document is filed with the court. There was a company that did not abide by this rule, but their company, the company was specialized in bankruptcy services. So for 3 years, they kept filing documents without following the rule until October of 2010, they started getting motions for sanctions by debtor attorneys. And they're like, why are we getting these filings? And they started doing some digging and realized they haven't been following the rule. And which meant for 3 years, from 2007 to 2010, they filed over 40,000 documents in 94 jurisdictions around the country. So that's when I was brought in with a group of other people to come in and clean up the mess. So we figured out how to deal with making sure that not only did you identify what needed to be redacted in terms of cleaning up the mess, you also developed a process to make sure that all data privacy rules were properly followed going forward. And because everything was based upon scanned documents from banks and creditors, you had a lot of handwritten documents, just like back in the day when I first started 10 years prior. You had a lot of regional issues. So for example, if you found some filings in, say, Louisiana, and you had a number of filings that were related to one particular bank, well, sometimes that bank would handwrite the debtor's social security number on the title. Well, you got to redact that. Another part where it was the state of Connecticut. The state of Connecticut is, if you bought a car in the state of Connecticut, you get a title, your birth date would be right in the middle of the title. If you and your wife bought a car, both you and your wife's birthday would be in the middle of the title. If you and your wife bought a car for your kid, all 3 birthdays would be on the title. So it's like, remember folks, if you're in Connecticut, keep an eye out for redacting birth dates on the title. And so you also had to make sure that the system would only display the last 4 digits of each account number on the proof of claim form. So it took months to clean that up. And we created training materials to make sure everybody knew how to handle it on a go-forward basis. And eventually, because I was able to help clean up the mess, they hired me on in their compliance and audit department. And I was very happy with that. However, because that regime mismanaged this rule for 3 years, they eventually got sold. And so we were acquired by a private equity entity. And so We continued on with our bankruptcy services, and I continued on with an internal process of making sure that we had policies and procedures in place, and there was quality control and proper document review and training and whatnot. But then, in 2013, the Office of the Comptroller of Currency issued this bulletin. And I'll just read the first paragraph. It says, the bulletin provides guidance to national banks and federal savings associations, collectively banks, for assessing and managing risks associated with third-party relationships. A third-party relationship is any business relationship between a bank and another entity by contract or otherwise. Well, since we were a bankruptcy service provider for creditors and other lien holders, that made us a third-party vendor for them. And since we were handling their GLBA data, we were subject to their audits. And for those people who work in the finance field for the past decade, understand what the fallout of this bulletin was, and it created an entire audit regime. It wasn't just big banks auditing vendors. It got the big four, like PwC would show up, and other big accounting firms would come in and audit us. We would have data security vendors who would come in and audit us on behalf of some vendors. And I basically became a tour guide. So, okay, you're in charge of this whole process. Okay, fine. So someone would come to the office and say, good afternoon, how you doing? I'd make sure they would sign in to the visitor log, and I'd make sure their state-issued driver's license was scanned. So we'd have a record of who was there. We'd give them a visitor badge. I'd escort them throughout the office. We said, okay, here's our server room. I badge in, go to the man trap. Okay, before I do my code pin for the server room, everybody sign the visitor log and the time in which you were here. We go into the server room. Yes, we have a raised floor. Yes, we have sprinkler systems. There's the cameras. We have the battery pack here. And then we go leave. Everybody sign out. Yes, here's our shred bins. We get our certificate of destruction every Wednesday. And here is how here. Excuse me, Mr. Coworker. Can we see your desktop? We got to make sure that your updates are properly installed and that your screensaver times out properly. And so this was back when we were still very much going to the office, and it was still very much an in-person event. And so I was doing that for a number of years. We had big clients would audit us 3 times a year, one IT audit, one legal audit, and one operations audit. And it was just a very involved process, updating policies all the time, making sure they all had the necessary screenshots from our Active Directory. But the other thing that I had the opportunity to do, as a result of this new responsibility I had, I became responsible for handling the company's SOC 2 reports. And they had been doing SOC 2 reports before they acquired us, and they were using the same auditor for a number of years. Great guy. I actually reached out to him last year to see if he wanted to be our SOC auditor for my new company. He says, we got out of it. Like, you sure, really? Like, we just didn't want to do it anymore. But a SOC 2 report, it's a report on the controls at a service organization relevant to the security, availability, process integrity, confidentiality, or privacy controls of a given entity. So if you look at this diagram, of the 5 trust principles, the one that is required to have a SOC 2 report is security. So for example, where I'm at now, we are doing security, we're doing confidentiality, and we're doing availability. The reason why we're not doing privacy is because we don't have HIPAA or GLBA documentation, and we're not doing process integrity because we're not processing payments. It's a B2B enterprise. We're not dealing with individual consumers. And so that's the reason why we're doing a test on 3 out of 5. But in terms of where I was before, we had all 5. And so as you can see, the first one being security, you got to verify that we have network and application firewalls. We have two-factor authentication for not only user access to the terminals, but also admins to our production environment. You make sure you have the proper intrusion detection. And you also make sure that people are properly trained on the requisite laws and rules that we have to follow in our given market space. And of course, availability, which means you have to have business continuity plans, disaster recovery plans. You're going to do tabletop exercises, failover tests of your database, and document all those things. More paperwork. Process integrity, because we're handling bankruptcy data, you have to make sure that the data feed back and forth with the creditor is properly linked with API gateway, making sure that everything is properly loaded, and any type of data that we input going forward that we get from the bankruptcy courts or directly from the debtor themselves is properly updated in the database. Confidentiality goes along with encryption, access controls, again, and network application firewalls. And privacy, again, it's not just the technical controls, it is the administrative controls as well. And because of this, doing a SOC 2 report for this company, I realized, oh, if we actually follow this playbook, you can eliminate all the risks, not completely, eliminate them, but at least reduce them significantly, so you don't have to worry about any other problems with litigation, or any other problems with rogue employees, or any other potential issues of government investigations. This process shows that everything is on the up and up, and it is a certain benchmark of corporate maturity for companies to show that they have SOC 2 compliance. So what are the reasons? The first one, you may have to have it required in if you're in your market space. So a year ago, I was working for a mortgage company, obviously not anymore, but that was a 5-year, the company technically existed for about 5 years before being sold. And into year 3, the expectation by all their clients was like, where's your SOC report? And that's one of the reasons why they brought me in, so that I can get their SOC report finalized. And again, the other reason is that the company suffered from a negative impact. So if they have a data breach, for example, then you're obviously going to want to make sure that you have somebody come in and make sure that all your controls are in place and they're validated. You can have a report say, yes, this should not happen again. Not to say that it will never happen again, but we can say that it should not happen with these new controls. Or in the case of where I'm at now, you want to gain a competitive edge for your products and services. While technically they had some contracts to say, yeah, we'll be SOC 2 compliant on X date, it became, and I'm very privileged to do what I'm doing now, because they said, we went to the board says we should have a SOC 2 report. We'll get, and since they're based in Santa Cruz, they're part of Silicon Valley, not Silicon Valley Bank, but Silicon Valley. And they said, we'll get the proper funding to make sure that you can get a SOC 2 report done in the next year. And so we are going to start our SOC 2 Type 1 audit next month. And then we're also going to do ISO 27001 audit later this year, because we have a lot of European-based customers, and so they prefer that as opposed to a SOC 2 report. And so of the many benefits for doing SOC 2, the first thing is all the controls that you do implement are very compatible with Sarbanes-Oxley, and you'll be able to do IPO if you really want to go public. The second benefit is that, as an example from what happened last year at my previous company, a SOC 2 report is a key document that is reviewed in the M&A process. So if you are a startup that doesn't want to get squashed by Big Goliath, but rather be purchased by Big Goliath, you give them that report and say, okay, we're compatible not just with IT controls, but business processes and your overall products and services. Yes, we could probably have a good way of integrating this into our overall umbrella of services. And then another one is you can lower your company insurance premiums. I mean, if you have a SOC 2 report and you go to your insurance carrier and say, hey, we got this. Can we get a reduced rate on our cyber premiums? So that's also part of another negotiation for doing SOC 2. Here are some sample vendors. There's Drata, there's Vanta, there's OneTrust. OneTrust purchased Tugboat last year, so it's called OneTrust now. I've used both OneTrust and Drata. We're using Drata now. It's one of the better platforms, but still a little twitchy. And so what you do is, if you want to use a third-party compliance platform, say Drata, you'll go into their matrix and say, okay, we want to do SOC 2. All right, how many trust principles? We want to do these trust principles. Where is your data? Is your data in the cloud or on site? It's in the cloud. Are you processing payments? No. You answer a few more questions, you hit submit, and they'll say, all right, you need to maintain 20 policies. you have 150 controls that you have to follow. And then you have to start gathering all the evidence to validate those controls. Now, one of the benefits of not only using Drata, but also hiring an auditor, and I've been doing this for the past 2 months with our auditor, we start negotiating. Is this control really needed? And so I would have these consistent meetings with our auditor and says, you know what? This control is more for privacy. You don't need this control in the scope of your audit. So I was able to get everything from 150 to about 100 controls. And even with the 100 controls that do exist, you can still tweak some of them. So like, for example, one of them says you have to maintain web application firewalls. Well, we don't have web application firewalls. We have API gateways. So you confer with the auditor and say, hey, we're going to change this control to say this instead, and we're going to upload this evidence to validate it. Okay, fine. And so you also have to make sure that everybody, personnel-wise, goes through the process to make sure that their laptops are configured, you prove that their hard drive is encrypted, that they use the proper password manager, they have the screen lock, they complete their security training, they acknowledge all published policies, and make sure their antivirus is up to date. Let's go back to what we discussed earlier with respect to UT. One of the controls in SOC 2 is that personnel sign an NDA, sign arbitration agreements. They also sign work ownership agreements. It's either one document or a combination thereof. Having this control shows that you want to make sure that your employees are aware of the working environment they're in, the data they need to protect, and things that should not be co-opted should they leave. You also have to make sure that people go through new hire and ongoing training. Training is always important in any corporate environment, but if you're also, particularly in the finance world, you may need to do training for anything that comes up down the road. So for example, Bankruptcy Rule 9037 that came out in 2007, that's one thing, but you had significant updates for bankruptcy in 2011 and 2013 and so on and so forth. So anything that changes with the laws that impact your business, you have to make sure that A, you recognize it affects you, B, you implement the necessary controls to update your services, and C, everybody is trained. And then, of course, you have a termination offboarding checklist. As we all know, 2 years ago, Colonial Pipeline got hacked. If they had a termination offboarding checklist, or at least periodic entitlement reviews, they can see that, oh, so-and-so is no longer here. Maybe we should disable their account. It was a year ago, I got a letter in the mail. I had refinanced my mortgage in 2017. And I got the letter saying, oh, sorry, we got hacked, your data's compromised. And I was reading the letter, and I could tell, based upon their explanation, as vague as they could try to make it, they did not do entitlement reviews. Somebody had improper access to their system, and somebody took my stuff. All right, so it goes. Executive controls. Have a board of directors for company oversight meetings. My company has a board of directors. FTX didn't. Maintain insurance coverage for all business operations. This is an ongoing challenge in the industry today. For those who were part of last month's presentation with Alias, there's a big debate as far as how much the threshold should be for covering cyber insurance. And there are those that say $5 million because the average cost of a breach is $4.5 million. But if your backups are up to date by the hour and you get compromised, you should be able to restore your data immediately. It's not like the old days where you have tapes in some warehouse. If it's all in the cloud, it's more on the cloud provider. It was a year ago, Heroku got hacked with their authorization tokens. Fortunately, my company didn't get hacked. They didn't suffer anything from that particular breach, but we still had to do due diligence. And again, going back to paperwork, I was doing screenshots of the Slack discussions and saved that for evidence to prove that we have incident management escalation processes. And then, of course, you have your policies updated, published, and enforced by management. You have a lot, depending upon where you're at. I mean, it's one thing to have 20 policies based upon what Drata said, but in the old days, when I was in the bankruptcy and finance world, I had 75 policies I had to update on an annual on an annual basis. The IT security policy alone was 25 pages long, and the revision history was 3 pages long. Because every time a client would come and do an audit, like, we want this little thing changed. We want this. Okay, fine, change it. But yeah, this is part of the process to make sure that you're compliant not only with your customers, but it demonstrates to the auditor that you're always keeping an eye on the ball. And so what happens if you don't have a SOC 2 report? Not to say that if, there's a Pollyanna mentality here, but ultimately, for those who've been in the cyber program and taken the compliance and legal issues class, there's always that 1 week where you learn about FTC enforcements, or as I like to call it, the wall of shame. And so this is the key lessons from the matter of light year dealer technologies that happened back in 2019. And as you can read, they failed to maintain documented company IT security policy, failed to implement training for employees and third-party contractors to safeguard company and consumer data. They failed to engage in vulnerability testing and external penetration testing. They failed to engage in incident management monitoring. They failed to maintain physical and logical access controls to company data. They failed to encrypt data when stored, and they failed to have a server hardening policy to install devices with the IT infrastructure. And if they had a SOC 2, all of these items would have been covered in some form or fashion, whether it be policy enforcement or any type of evidence sampling to prove that those controls were in place. And so that is where I'm at now, and that's what it's been like for the past 25 years for me. And I've pretty much been doing paperwork, and I'll probably be doing paperwork until I retire. So the question then becomes, what's the future? I would strongly recommend everybody reads the National Security Strategy of March 2023 that was published at the beginning of the month. It's about 35 pages. It's high level, but it's a good introduction to see what the government wants to do going forward with respect to how we want to have more cybersecurity rules and regulations. I have a few comments about it, but I'll reserve those for later. With respect to AI technologies, we're going to have an integration or we're going to have a prohibition of them. Just before I came in here, I noticed that Italy banned ChatGPT-4 because it may infringe upon data privacy and GDPR standards. So who knows how that's going to work. New laws and regulations for cryptocurrencies. As mentioned earlier, FTX had its problems, not just the fact that it was a scam, but when you create some type of platform like that, are you creating a multi-tenant infrastructure or is it a single tenant infrastructure? Because if you're going to create an environment where people are giving you their money in some form or fashion, they should have their own bucket per se, right? It should just be all in one bucket. So how do you differentiate everybody's quote unquote account for crypto? And that also begs the question, will the government finally step in and say crypto is either a currency or an asset? Because if it's an asset, that's going to be regulated by the SEC. And if it's a currency, it's going to be regulated by the Department of Treasury. So it would be nice for the government to say, hey, this is the way it should be going forward. Antitrust actions against big tech. So the last time anything like that happened was 40 years ago when AT&T was broken up into 7 different regional carriers. Is Facebook going to be broken up? Is Google going to be broken up? Is Amazon going to get broken up? We already can see that the walls are closing in on TikTok and trying to divest them completely from China if they still want to operate in the US. But that's another issue that may come up. And then new laws and regulations for social media data. We saw what Utah did in terms of making sure you had parental consent if kids want to access social media accounts. Thank you, Matt Davis, for posting today that Iowa has become another state to create its own privacy laws. So there's always something going on. The question is, where do you want to go and what do you want to do? But whatever you do, if there's one thing for certain, you're always going to have some paperwork to take care of. So with that, does anybody have any questions? Anybody in the chat? Any questions here?
So is the SOX 2, is that required or is it just optional?
Depending upon where you're at, it's not legal, but it's mandatory. Like I said earlier, The finance world really does expect it, mainly because of Dodd-Frank, and because of that bulletin from Office of Control of Currency. But again, would you, and again, it goes back to corporate maturity. You know, there's a lot of money involved of the audit, not just the controls you put in. You should already have things in place to make sure that your environment is secure. And that's one of the reasons why I like where I work. The company is 10 years old. So because it's 10 years old, because it's a SaaS, there is very little paperwork, very little work at all. And so the question is, where you're at, how much do you have to corral in terms of administrative controls, in terms of technical controls and physical controls. I remember speaking with Christopher here back in December. It's like, you know, he's working facilities manager, but we're all still doing remote work. I mean, my stuff's remote work. So if we still want Christopher to have a job, we still have to go to the office, right? So it all depends on where you're at, and it all depends on whether or not the company is willing to make that commitment. But I mean, it really is a good way of promoting, you know, best practices and validating that you do have best practices and that you're a good actor out there. So it's also part of reputation management as well. And whether or not a company wants to do it, it's entirely up to them. Let's see. Christian asked, hi, would you say the current compliance laws are effective for protecting users? Excellent question. I have one point. If social media data was protected in the same way as HIPAA and GLBA with a new piece of legislation, I think that might solve a lot of problems. This is a high concept, but rather than trying to force breakup of big tech or trying to force what people want to do with TikTok, for example, if you passed a social media account privacy legislation, it really would drain the swamp per se. The question is, how do you enforce it from a legal standpoint, an administrative standpoint, and then how do you change the data processing that's done in big tech? And of course, as we all know, the algorithm does so much, we don't even know what it does, but we expect them to know what it does. But you know, so there's that aspect as well. So hopefully, Christian, that answers your question. Yes, sir.
To follow up on that idea of a law regarding social media data, I think if you were to protect it similar to GDPR or HIPAA, you might put the industry out of business since they're predicated on taking your data and shopping it around to interested parties.
You mean we actually learn how to talk with each other again?
That would be horrible, wouldn't it? We'd have to do something like this.
You mean we actually learn how to be civil again?
Yeah. While I am firmly in the camp of something needs to be done, boy, you know the social media companies, if you tried to protect social media data along those lines as suggested, boy, they would fight that tooth and nail. But it probably needs to happen.
Yeah. I mean, it's again, as I highlighted earlier, in the 90s, Congress knew how to function. They knew how to work together. Do they know how to do that today? And to your point, back to your point about GDPR, and the national security strategy did highlight that, oh, we want to make more effort to streamline the process. Okay, well, what do you mean by streamline the process? Do you mean adopt something like a GDPR light for the US? Or do we want to take a bunch of the laws that are already on the books and streamline them into something a little more uniform? Because we have all these little different pockets. I will say this, as onerous as Dodd-Frank may have been, it really did a good job of making sure that the finance world straightened up and was flying right. And I asked the following question, regardless of what has happened with FTC and Silicon Valley, or FTX and Silicon Valley, how many times has a major financial institution been hacked since Dodd-Frank? Anyone? Anyone? I can't think of anything. Whereas, as I said earlier, HIPAA was the first piece of legislation to do privacy and security rules. How many hospitals and other healthcare providers are getting hacked? But they don't have the sword of Damocles hanging over their head in the same way the finance world does, because HIPAA is enforced by Health and Human Services. And so Health and Human Services had some type of legislation that not only gave them the authority, but also the budget to go around and say, hey, hospitals, maybe you should start doing pen testing. Make it a requirement. That would help.
Actually, they do. Now,
but do they have the manpower? Do they have the same level of, because I don't want to be completely crass, but okay, your health data has been breached. What does the health entity do? They put you on a spreadsheet on the HHS website. Yeah, here it is. We'll send out the letter.
well, it gets you an OCR investigation.
Right, but at the same time, the other problem is that the FTC starts going after the healthcare providers, when in fact that should be an HSS thing, right? And so where's enforcement? Where's the due process? How should it work? You know, because if it should be done for everybody, and I mean, this will benefit cyber professionals in that if you have more opportunities for this type of work to do, particularly in healthcare, then yes, you'll have a more robust cyber personnel on staff. But there is no carrot and stick, or just a stick for that matter, to make sure it happens. So, hang on, let's look at the. Hang on, let's look at the Christian. Ah, yes. Thank you, Christian, for the question. As far as signing your life away, he says, I think that most users don't appreciate the value of their data. What do you think can be done to educate users to care, to appreciate that their data, be it intangible, as is valuable to their tangible assets? How can EULA or similar protection mechanisms be made simpler? So, well, one of the fundamental problems, it's all free. So if it's free, then who's the product? Oh, that'd be you. If you paid for it, two things happen. One, the companies make money. Not a whole lot of money from ad revenue, but at least they're in business. And two, your data would be protected, right? I mean, I have my LinkedIn, that's about it. You know, I don't, and my buddy who's in Tokyo, he was like, how can you run on WhatsApp? I'm like, I don't want to use WhatsApp. He's like, why? What does it matter? I'm like, I don't, is it encrypted? I mean, if what I put on WhatsApp going to be accessible to Mark Zuckerberg and Meta? He's like, so? I'm like, okay. So there are significant cultural hurdles here. You know, if people understand what the cause and effect is, then, you know, if you're responsible for your own data hygiene as an individual and making sure that, you know, what you post or what you upload or do this or that, there's that level of personal responsibility. But at the same time, you got to make sure that we know what the culture is and what the rules of the road are. So thank you, Christian, for the follow-up on that. Anybody else here? Yes.
Richard, what would you say for someone getting into the industry, trying to be as marketable as they can, going to find a job? How would you say, what would you say might be an important piece of going into the intel side of cybersecurity? How important is it for a cybersecurity professional to have a little bit, at least a little bit of intel?
So the one thing you have to realize is cybersecurity does not operate in a vacuum, right? So depending upon whether you're in the medical field or the financial field or in the SaaS field or anything else, you have to know the company you're working at, the market space you're in, and any potential regulations that go along with that, right? And so, for example, and I'm not here to denigrate or anything, but I understand that there are a lot of people on their LinkedIn profiles that say aspiring this or passionate that. I simply say cybersecurity. I do SOC 2 and I do ISO 27001 certification. That's my wheelhouse. So my suggestion is, if you guys or anybody else that want to seriously worry about vulnerability management, own the MITRE attack, just know it back and forth. Like, so for example, I said I used to do bankruptcy. I can still tell you how to determine the difference between a Chapter 7 and a Chapter 13 claim, and within Chapter 13, there's all these other different subsets, and like, I know it. And if I get back into it, I can pick it up again. So if someone wants to own the MITRE attack, know how that works. There's another big thing that's really missing, particularly because of everything that happened during COVID, because we all went online and we were doing a lot of payments online, there's a lot of online fraud. Know what it takes to know how PCI works. And if you look at PCI, I mean, I've dabbled in it enough to know I don't want to have anything to do with it, but when I have to dabble with it, you realize there are different merchant classes. Are you a merchant? Are you a service provider? How does that, that data need to be validated? And again, going back to what they were talking about, streamlining regulations, PCI is not a legal standard. That's an industry standard by the payment card industry. And so is that something that the government wants to take over? Or they're like, hey, you guys got this, we're good here. But like, that still involves training, that still involves pen testing, that it still involves screenshots or firewalls. And that all depends upon whether or not your company is processing and storing PCI data. You can sign up for Stripe and let them do all the work for you. And your PCI paperwork will be 5 minutes. That's what my company did before I started. I'm like, I noticed we're using Stripe and I want to know what our merchant class was. I'm like, that's it? As opposed to other places where it's like, you have a 100-page questionnaire that you have to complete for PCI. And we need more qualified vendors for that. You can work for a company that does the continuous vulnerability scanning. You can become a pen tester, but you can drill down. You can do MITRE, you can do PCI, you can do anything else that goes along with those requirements. Because everything, and again, this is a great program, but because you're only doing things in 12 weeks, you're only touching the surface. There's a lot more to silo in a lot of things. Question from Quilla, is there a career path that is a combination of GRC and cloud? Yes, I'm working on that right now. Because a lot more companies are going to the cloud, you have to paper up just exactly what those controls are and validate that, where your responsibilities are as a company versus what the responsibilities are with cloud. So for example, if an audit question is, tell us how often you patch your servers. We don't. Here's the SOC 2 report for AWS. Not to say that we're off the hook, but that's the proof in that you sign up for that service and you make sure that the cloud providers do X, Y, and Z. What do you do for capacity planning? We don't. We already have that built into the service. They know how much more data we need to have, and they'll give us more space as a result of our subscription. But you have to paper it up. And so that's another challenge in that I need to make sure that everything that my company is doing is validated in some form or fashion, whether it's the GCP or the Heroku contracts or their SOC 2 reports that say this is what we do for our service providers. So yes, more. And the other thing about cloud is that as we consolidate, there is the danger to say, well, everybody's going to have everything in Northern Virginia. Okay, that's going to become a bigger target. But it also gives other companies the opportunity to start other smaller cloud providers around the country. Because if Northern Virginia has some catastrophic power failure, what happens to your data, right? Can you go someplace else in the middle of the country that doesn't have as much data traffic or power demands? And so don't just simply say AWS. There are other providers around the country. So yes, that's an excellent question. Well, thank you for that. Anybody else have any other questions?
I do have a question about the SOC too.
Okay.
If it's as final as you say it is, why is it not being used as much? Is it restricting companies data?
So again, it goes back to what I said earlier about corporate maturity.
Yeah.
Some corporations, it depends on culture, right? And whether or not executive leadership is going to want to make that dedication. And again, I'm very fortunate where I'm at. So for example, when I got hired, one of the first meetings I had, we had, of course, all hands online. And they talked about how every quarter we're going to have a rock. And we're going to build on this rock to say, this is how we're going to improve the company. And they had 4 rocks for Q3. And I was the 4th rock. Like, we hired Richard Pierucci as our compliance manager to make sure we get SOC 2. And I'm like, thanks. And it's just like, right then and there, I realized what I will do, it's not just a report and create paper, it's also a significant impact in the corporate culture. So I want to tread lightly. I'm not going to run around like a chicken hawk and with a little clipboard and say, well, you're not doing this right, you're not doing this right. Learn the culture, learn how the business works. Make sure, is this a valid control, or is this a valid concern? Are there any gaps that we need to fill before we actually move forward and try and use a third-party platform and ultimately get a SOC auditor to do our report. And so it took time to like learn everybody, what they do, how we do, what our cloud structure is. In other places, someone just wants to be the boss. It's my way or the highway. And you're gonna get that in certain corporate environments. And again, it's like, do they want to dedicate the money? So, and I don't want to like bang on the drum of every disaster, but like, for example, Silicon Valley Bank did not want to be the adult in the room. They had $50 billion in assets, and then they realized they were going to be beholden to stress tests for Dodd-Frank. Rather than own it, what did they do? They spent $500 million, or was it 500,000? Either way, let's say $500,000. They spent $500,000 in lobbying, both Republicans and Democrats, to change the law, to raise the threshold from $50 billion to $250 billion. $500,000, that's what? 2-3 people on staff for a new risk department? Let's say $750,000. This is $750,000 a year for staff, for testing, for other resources. They would rather get off the hook and not be responsible for $50 billion in assets. Now, granted, you can't predict a pandemic and inflation to ruin all your investments, but at the same time, that's a corporate culture thing. We don't want to be responsible. You're the top 20 bank in the United States, and you don't want to do a stress test. Okay. Again, this does not operate in a vacuum, and you will learn that cyber can take a backseat to other priorities in certain companies. And because, again, it can become a power struggle. It's like, I don't want to do that. Going back to the challenges of the 90s, just getting to the 2000s, this is when FACTA was passed about, shredding documents and getting rid of hard drives. And I remember working, and we brought up the issue of, well, if we're gonna have all these laptops and desktops, we should spend money on having all their hard drives shredded. And the response was, oh, we don't need to do that. Okay. And if you're gonna get that response from that one little thing, what other big thing are they gonna say no to? So again, it's just understanding what these things are gonna do, cause and effect, either in the boardroom or in the IT department or anywhere else. It all depends on where you're at. So like I said, I'm very fortunate to be where I'm at. I've been at other places where, it was not as much of a priority. So, but it's an excellent question. But again, personal responsibility and corporate governance, they're going to have to go hand in hand in some fashion, and what the rules of the road are and what the playbook's going to be. So.
Maybe. I don't know a lot about SOC 2, but it's not being used a lot. Maybe it's because it's either very restrictive on companies and it requires a lot of cost for the company.
So that's an excellent question. So here's a classic example. People may think that this is all you can do. These controls control you. No, you're not. Sherry, you'll appreciate this. Do you capture the moment or do you make the moment in photography? Answer is yes. You're doing both. If a SOC 2, so for example, the controls of like, okay, do you do backups? Well, yeah, but you can, through these third-party platforms, you can configure, say, draw it to say that, yes, you're getting everything backed up via Heroku. Do you push code properly? Yes. You have your API connection with GitHub to show that everything's being done. It's not, that's the other problem. Like, don't think of it as like some nanny thing. Don't think of it as big brother saying you're going to do this or that. I mean, you still have to do your penetration testing. You still have to do your annual training. You still have to do your your tabletop exercises. But if you incorporate it into the culture, you'll be a stronger company. Yes.
Let me add to what he had said. My company does healthcare finance. So we do PCI DSS, we do a SOC 2, and we do high trust. I run 3 audits a year, plus questionnaires and attestations and things like that. It's not that PCI or a SOC 2 or high trust are prohibitively expensive. We only have 80 employees. Every time the Federal Reserve raises interest rates like 0.25%, it takes about $500,000 out of our cash flow. We still have to do these things in order to be a reputable business partner. If you as an enterprise are serious about that reputation word that he had mentioned earlier, you do these things. You can do a SOC 2 for $100,000 or less. Now, you don't want to necessarily get too cheap. There is a saying that we're not big enough to afford cheap fill in the blank. Hardware, auditors, whatever the case may be. But you can find an audit provider that will do your SOC 2, that will do your high trust. At times, you can find people who will do a SOC 2 and a high trust simultaneously because they're that similar. PCI, it's a different animal. But the bottom line is, if you are serious as an enterprise about doing business in whatever space you're in, you find a way to do these assessments, these audits, because it demonstrates, just like a CISSP demonstrates that you're a legitimate cybersecurity professional, one of these audits for a firm demonstrates that you have a serious and mature program. And the way I look at it, if a company doesn't want to do high trust and they are in the healthcare space, run. And if they're not willing to do a SOC 2 and they're in any other space, maybe walk. But that demonstrates a lack of maturity. He has used that word several times. It's a critical word. Maturity and culture are vital to an enterprise. And if my company with 80 employees can do all 3 of these attestations, even with the Federal Reserve leading us wide on cash flow, and it's been brutal this year, we just have to structure that cost in and pass it on to the customer. That's just what you have to do. Because otherwise, we can't be in this space. We have no way of justifying our program. We need that third-party attestation. We need that endorsement. So, my last company, we had healthcare data on about 1 out of 3 residents in the United States. We had 596 high trust controls and 350-ish SOC 2s. Company I'm at, it's a little more modest, but it's still kind of big. And it's just what you have to do. I mean, it keeps people like me and him employed. And y'all, in the future, will be employed because of stuff like this. So, in a way, we kind of need to sell the benefits of compliance. Who's had Dr. Blank here? Does she still teach foundations? Or not? Okay. The first night of my class, I graduated in 2009, so I'm right here. Dr. Blank told us that information security is neither cheap nor convenient. That's like the first thing she told us in the foundations class. Burn that into your head. What we do is insurance. And good insurance is not cheap and it's not optional. Unless you want to be a fly-by-night outfit. And I'm taking away your time.
No, everything you said in terms of cost, I'm glad you brought that up because these third-party platforms are driving the cost down.
Yeah.
So for example, before I started doing all this with Drata and Tugboat, it was a much more manual process to do the internal tracking, and the cost for the actual external audit was a lot of money. Now it's going the other way around. You can depending upon your overall profile for an audit, you can do, say, Drata for 20 grand a year, and then another 10 grand will get you an annual audit report, which is cutting the price down in half.
Speaking of Drata,
Yes.
have you seen the partnership that they have with an outfit called Hypercomply?
Not yet.
Check it
I
out.
will ask them. I have a bi-weekly meeting with them, and I'll ask my customer rep about that on Wednesday.
You're gonna love it.
What's it called again?
Hypercomply.
Hypercomply.
Yeah, they're up in Canada, but in a nutshell, what they do is they use AI to fill out all these questionnaires for you. Big time saver.
That's better than RFPIO.
I used RFPIO at my last job, and by comparison, it's a little clunky. Hypercomply, now, I'm not using Hypercomply commercially, but I've done demos with them, and check it out. They are kind of joined at the hip with Drata. They have like a API between the two of them.
I'll definitely check that out.
It's nice.
But yeah, I mean, and to what you were saying is your insurance. I mean, view these audits as an investment. You know, because back in the day, I say back in the day, pre Dodd-Frank and pre the OCC bulletin, you know, you'd have people go in and give their presentation on this is what we can do. Well, now, particularly in finance, if you want to get new business in finance, you are being audited from the get-go. And if you have a SOC 2 audit to give them, that's another reason why I'm doing what I'm doing where I'm at. They're like, it will streamline the RFP process. We can give them a SOC 2 report, we can give them our certificate of insurance and a standard information gathering questionnaire. Here. Okay, cool. A few more questions, back and forth, redlining on the contracts, make it more of a week's process as opposed to a month's process to get new business. So if you have that mentality and you sell it that way to the executives, they will definitely be all up for that. There's always an IT language and a business language. Classic example, pen testing. If the pen test gives both a reason for a business case as well as an IT case to get things done, then the business folks are going to want to cut that check faster than, because they can understand why. You have to speak both languages, you know.
If you can speak from both sides of the fence with equal fluency, you will make yourself priceless in the job market. And InfoSec is a tiny community. Even in DFW, it is tiny. The most elite guy that I've ever worked with, the thing that separates him from everybody else is he can write a graduate level report in business language and then turn around and rewrite that report in geek speak and present it to DHA, Dallas Hackers Association. He could go from a boardroom to DHA without breaking a sweat. That guy he walks on water. He has a reputation. People told me that I would be working with him at my last job and that I was going to really, really love working with him. Absolutely correct. I sought him out and I made a point, he was our white hacker basically. I made it a point after meeting him to change every my password. He just gives off that vibe of, you know, you think you're secure, but you're not. So it's a small, tiny world. Learn to speak both those languages and you will go far. If you can't speak business, you're not very useful. Okay? The paychecks and the funding comes from business people. You can't meet them where they are and speak their lingo. You got one arm behind your back all over, and negotiation is hard. Give yourself both your hands. Speak both. Oh yeah, all you MS guys.
Anybody have any other questions from the chat, from the room at all? Yes, Professor.
Richard, that talk was fantastic. Thank you. First of all.
Thank you.
Second thing is about the here and now. An MS student who has not had the kind of experience that you have had. You started with GRC at a time when GRC was not a thing, it wasn't called that. Cybersecurity was just beginning to gain some kind of traction. But for students of this time, they know GRC is a field in cybersecurity, privacy is its own thing, pen testing is its own thing. So how can a student finish this MS program in cybersecurity and make their resume stand out apart from others in applying for the GRC position? Jessica here is in my class, and a whole bunch of students in that class want to get into GRC because frankly, they don't like the coding part of cybersecurity. So what advice would you give for students like them? How can they?
That's an excellent question. And I think one of the challenges is twofold. One, there's still a lot of remote work. So the fact that you're not in the office with that visceral experience to know who's who, what's what, and what's going on, that's one component. The other thing is that, as I described, in terms of Drata, Vanta, and OneTrust, I would strongly suggest you go to all those platforms and ask for a demo, because they are really improving the process and making it more user-friendly. The catch is at the expense of the very experience you're talking about. So back in the day when I was in the office and I was doing those 75 policies, I would be in the office with everybody and I'm walking around with my paper and I was like, okay, GC, please, do the legal review, and thanks, you can get that big bar. And then I'd have to hand it to the IT guy. And if it's an accounting thing, hey, you don't have that pass around developing that institutional knowledge. And that's one of the real catches. So if you do the demos for those platforms and you see how they work, because that's what I do. I use Drata to do the policy development, and I work with everybody remotely, and make sure all the executives edit and approve it in the system. You also learn how to see what the controls are. Go through the demo process, like I say. If you want to learn SOC 2 and you want to do all 5 trust principles, and you have your data in the cloud, press the buttons and see all the stuff that you have to do. And it's just like I said, we only 3 trust principles, and we started with 150 controls, and learn why and why not they would be applicable to that particular environment. As the old saying from, I think it was Magnum Force, Dirty Harry, how can anybody get any experience if you don't give them any experience? I think that's one of the challenges we're in right now in the industry, and that, and as we all discussed in various cybersecurity club meetings, oh yeah, that entry level position with 20 years experience. It's like, gotta start somewhere, right? But look at all the possible free demos there are for those platforms. If you want to do GRC, I'm obviously available if anybody wants to talk about it. I'm on LinkedIn. You guys can find me on LinkedIn. And of course, you'll recognize the clean-shaven image, not this. But ultimately, yeah, the challenge is getting your foot in the door. But again, like I said, what is your position? What is your company? what is your market space, what are the regulations. If you view it from that perspective, that multi-layered perspective, that will help. So like, as you talked about, you're in healthcare. Healthcare has got its own culture and quirks. Finance got its own culture and quirks. SaaS has its own culture and quirks, and you just got to learn it. There are a lot of people doing online certifications, which is a good thing. That'll show that you're able to learn on your own, and you're not just simply doing something in the classroom. Because they want people to solve problems on their own, especially if you're still working remote. It's just you and your laptop on the couch. So, be able to make sure that you can do that. But properly wording things. Here's a classic example. The founders of our company are originally Russian immigrants. They settled in the United States. And they also did a lot of work having code developers in Russia. And the invasion happened last year. They did two things. They signed a contract. They created an amendment to the contract to get the money out of Russia into the US-based entity, and they worked to get everybody out of Russia and Ukraine. So now we have workers in Sri Lanka, Thailand. I spoke with somebody in Serbia today. We got her in Brazil. Here's the catch. They're all refugees. So one of the controls is, do you perform background checks on your contractors? Well, if we did background checks on our contractors, it would be based upon the Russian passport, and the Russians would then know where they are. So our auditor was really cool. I had a meeting with her last week. She says, this is what you do. Go to your employee hiring and termination policy, and you write a sentence or two with an exception. It says, any employee who's a refugee or political dissident as a result of acts of war, terrorism, natural or man-made disasters may not be subject to a background check until they get new credentials in their country of origin. I would not have had that experience of making that edit had I not worked where I'm at now. And those are the little quirks that we're trying to find in terms of GRC. Like, we're not trying to not do a background check, because I had that meeting on Thursday, and then last Friday, there was a YouTube channel called Caspian Reports that dropped a video about the forever war in Ukraine, and halfway through the video, they're talking about how Russia is working on a database that can track and summon all expatriates to become conscripts and put them on the front lines. We are not doing this change out of paranoia. We are doing this change in our policy to protect our contractors. It's a legit thing. But again, unless you're actually working someplace and you don't have that challenge to solve, you wouldn't know what to do with it. So you have to, getting into the whole hopper of it is extremely important. And just, again, knowing the business model and knowing the culture and the whys and whats, that's the key. So yeah, there's a lot of online demos. Just do Google searches for company policies and read how they are and why they're written. Are they high level stuff? Or are they like really in the weeds, really detailed stuff? So, and again, yeah, you have to work with the IT guys. Like I said, if you're in a small company like mine and you have your change management policy, there's no such thing as a change advisory board. It's like one or two people that press a button. Just make sure there's the proper segregation of duties to make sure, yes, this person tested it and this person implemented it. So long as you document that so-and-so does this and so-and-so does that, you're good. And you have it all documented in your JIRA tickets. But yeah, there's just getting into the weeds. It's a greater challenge because A, we're not in the office as much, and B, a lot of things are automated. So yeah, I can appreciate that challenge. So, does anybody else have any questions? All right, cool.
Since there are no questions, let us thank Richard for his time.
Okay. Thank you all.
Thank you.
Online. Thank you all online. Yeah. Click on that.
Thanks, Richard.
Thanks, Aiden.
Thank you all. Have a good night.
Very good.
Was about
You busy?
I submitted my official.